I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on state open meeting laws. As a reminder, all of our classes build off one another, so if you haven't already, please view our previous lessons on open meetings and executive sessions. They'll give you a good overview of the law and lead into what we'll be discussing today. We also have a growing library of lessons on state public record laws and the Federal Freedom of Information Act. All these lessons can be found on our YouTube channel, as well as in our FOI guide at nefac.org/FOI guide. Before we begin this lesson, a special thanks to those helping us make these classes happen: the Society of Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on state open meeting laws. Now, this session is going to focus on citizen participation in government meetings in Vermont, and with us is Lia Ernst. She's the legal director at the ACLU of Vermont, and she's going to explain about making public comments during open meetings in Vermont and give us some tips and advice for citizens who would like to make their voices heard at those meetings. Lia, thanks so much for joining us today.
Thank you, Emily, and I am happy to be here. For purpose of today and my comments today, I'm going to assume that the gathering is in fact a meeting within the meaning of the open meeting law and is in regular rather than executive session. The short version of what the open meeting law is for is to ensure that the people can hold their government to account. The open meeting law and the Public Records Act both set out to do this. And specifically in the open meeting law, the legislature set out its statement of purpose as saying, the legislature finds and declares that public commissions, boards, and councils and other public agencies in this state exist to aid in the conduct of the people's business and are accountable to them pursuant to Chapter 11, Article 6 of the Vermont Constitution. Article 6, in turn, of the Constitution states that all power being originally inherent in and consequently derived from the people, therefore, all officers of government, whether legislative or executive, are their trustees and servants, and at all times, in a legal way, accountable to them. So as I always say during open meeting law or Public Records Act presentations, these laws are not a matter of legislative grace, bestowing upon us rights otherwise lacking. They instead are the statutory realization of a constitutional command. And I think it's important to have that framework in mind as you're thinking through these issues, that it is your right bestowed upon you by the Constitution to insist upon government accountability and openness. So as I mentioned, the open meeting law is one of the ways in which the government is accountable to us as required by the Constitution. So we'll talk quickly about the rights that the open meeting law does give us. As talked about in much more detail in an earlier presentation, the open meeting law gives us a right to notice of meetings. It requires the government body to take minutes of its meetings and make those minutes publicly available. They are available to us both under the open meeting law and the Public Records Act. We have the right to attend meetings, except not executive sessions. And most importantly for today's purposes, and I'll quote from the statute here, the public shall be given a reasonable opportunity to express its opinion on matters considered by the public body during that meeting, as long as order is maintained. Public comment shall be subject to reasonable rules established by the chairperson. Now, not all states provide for a statutory right to participate in as opposed to simply attend public meetings. But even where there isn't such a statutory right, public bodies generally do give life to the constitutional right to petition the government by setting aside time for public comment during their meetings. Vermont takes it a step farther and explicitly spells it out in statute, which I think is a good mechanism of public accountability. And, I think that's an important and helpful area of Vermont law. But regardless of whether there's a statutory right to give public comment, Once a public body decides to open that opportunity up, its regulation of the public comment period is constrained by its obligations under the First Amendment, which we'll get into in a little bit. So as we discussed at the top, we have both expressive interests and government accountability interests served both by the Constitution and by statute. But in practice, sometimes one person's interest in these things can come into conflict with someone else's, and that's where some of the more difficult questions arise. So most obviously, there's the speaker's rights to freedom of speech and to petition the government. That's protected both in the United States Constitution and the Vermont Constitution. The First Amendment of the US Constitution provides that Congress shall make no law abridging the right of the people to petition the government for a redress of grievances. Our own Constitution in Article 20 of the Declaration of Rights says that the people have a right to instruct their representatives and to apply to the legislature for redress of grievances by address, petition, or remonstrance. So this is core political speech, this giving of feedback, even harsh criticism to public officials is absolutely fundamental to representative democracy. That's why the United States Supreme Court has said that the First Amendment reflects, quote, our profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. And that's true even when it includes, quote, vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Similarly, the court in another case has said that the vitality of civil and political institutions in our society depends on free discussion, and it is only through free debate and free exchange of ideas that government remains responsive to the will of the people and peaceful change is effective. Okay, so we have this core fundamental interest in expressing ourselves through our free speech rights and expressing ourselves to government through our petition right. So you have that interest in addressing a public body, but so do I. And if your exercise of your interest in petitioning the government prevents me from exercising mine, how is a public body to deal with that? Along the same lines, we have an interest in learning what the government is doing in our name, but another person's assertion of their interest in addressing that body may hinder or even prevent me from hearing from my government. And so we see these instances of conflict between these rights. Similarly, we have a right to receive information, including by hearing the comments of other members of my community. So if the government overly suppresses public comment, it's interfering with my right to hear what members of my community has to say to the government. And then, there's just a more general interest in the effective functioning of our public bodies. And in extreme cases, people's expression of their individual interests may derail entirely the body's work. And lastly, the body itself has an interest in hearing from us, the public. As the Vermont Supreme Court has stated, without the sharing of opinions and concerns, public bodies would be less able to fully and competently serve the public and construct beneficial decisions for the people. So we have all of these rights at play in this public comment session. And the question, I think we'll spend a bit of time on today is, how do these interests shake out? How can public bodies properly regulate public comment to ensure that these interests all receive their due? As I stated at the beginning, the Vermont open meeting law allows the public body to set reasonable rules, but it doesn't otherwise give much guidance as to what counts as reasonable or unreasonable. Thankfully, though, the First Amendment and the Vermont analog Article 13 and cases interpreting those provisions provide significant guidance, and the touchstone there is also reasonableness. And I should say here, there is some inconsistency in the case law on these issues, and not all of these, not all of what I say will be absolutely established in every district across the country. But what follows is the majority interpretation, and I will include Vermont specific law in here too. It's also important to note that in practice, these analyses can become extremely fact specific and are judged on a case-by-case basis. But these general principles that I'm going to lay out will guide the analysis in every case. So a public comment session is what's known in First Amendment doctrine as a limited designated public forum. So let's break that down a little. Designated, meaning the body opened up this forum for the purpose of allowing speech. It designated this forum for that purpose. And limited, meaning that the topics that can be addressed may be circumscribed by the body, or even it can be opened up only to some relevant subset of the population at large. So let's dive into that a little more specifically. The public body can adopt reasonable, objective, topic-based or speaker-based restrictions. So let's focus on topic first. Sometimes a public body will open a public comment session specifically to receive comment on a particular proposal or policy or topic, and the body can permissibly limit comment to that subject matter. So if we're considering, a proposed bill on a no trespass ordinance, the agencies can say public comment will be limited to that bill. More often, at the beginning of a meeting, often the public body opens it just to public comment on whatever the person wishes to bring to the body's attention. But the public body can limit that more general public comment period to matters within the jurisdiction of the body. And so if someone wanted to address the body, let's say a municipal select board, on its view of the nuclear treaty with Iran, that is clearly outside the jurisdiction of the municipal select board, and the board can permissibly say, we're not going to take comment on that. That is not related to our jurisdiction. Sometimes you'll see public bodies restricting comment to items on the agenda, or other times they'll restrict public comment to items that are not on the agenda, because there will be specific time to discuss the agenda items, and the public comment session is meant to bring up things that the body isn't otherwise considering. So that is sort of the limits that the body can put on the scope of the topics of the public comment session. But once we're within that scope, any content-based restrictions on speech within it must generally satisfy what's called strict scrutiny. This is an exacting form of judicial review that requires that such restrictions be what's called narrowly drawn to achieve a compelling government interest. Now, that's just a lot of words to say that such restrictions generally are not permissible. Examples of content-based restrictions that would probably not be permissible are restrictions on, uncivil speech, restrictions on referring to a public official whose conduct relates to a relevant topic, restrictions on profanity, restrictions on speech that is offensive to the sense of propriety, which I've seen in some rules, speech that is discourteous or disrespectful or rude. All of those are unlikely to withstand constitutional scrutiny. Even more likely to fail any sort of judicial review is any sort of viewpoint-based restriction. That's flatly prohibited. So that is, a body can't say, all right, we're opening a forum to talk about this proposed ordinance, but only people in favor of it are allowed to speak. Only those who share this viewpoint can speak about this proposal. And that's just flatly unconstitutional. So that's the topic-based restrictions. And then the second part I mentioned was speaker-based. And in some instances, depending on the facts, a body might be able to limit public comment to residents of the town, but that restriction might end up being unreasonable if it excludes non-residents who are equally affected by the body's decision. Likewise, a body may restrict comment to those who are specifically affected by the proposal under consideration. Again, as with the topic-based restrictions, if the speaker is within the category that the forum was available to, any exclusion from that person within the scope must also satisfy strict scrutiny. And again, any restriction must not be based on viewpoint. That is, just flatly impermissible. So that's sort of, restrictions that a public body can put on the public's abilities to comment on the scope of public comment, who can speak and what can they talk about. But bodies can also adopt what's known as reasonable time, place, and manner restrictions. That is the when, where, and how of someone's speech. And essentially the rule here is that the restriction, again, must be content neutral, It must be narrowly tailored to serve a significant government interest, and it must leave open ample alternative channels for communicating the speaker's message. Now, note that that narrowly tailored to serve a significant government interest prong sounds strict, it sounds stringent, but in practice, it really isn't all that stringent, nowhere close to the strict scrutiny that I was talking about just a moment ago. Basically, if the regulation promotes a substantial government interest that would be achieved less effectively without the rule is probably okay. And the sort of government interests that we look at here are, the interest in the orderly conduct of the meeting, the interest in preventing speech that actually disrupts or derails a meeting. So under this test, the sort of time, place, and manner rules that are likely to be withheld, depending on the facts, are time limits, so long as they are reasonable, both as to individual commenters and the comment period overall. A requirement that people speak only after recognized by the chair, so you can't just have people standing up and screaming out things over top of one another. And then in instances where there are, a long line of folks who want to speak on a given topic or during a given session, it may be reasonable to require folks to sign up and then, take those people in order. And these are the same rules that govern expression during public comment, govern expression during a public meeting, besides that expression that is speaking during public comment period. So, people might carry signs to the meeting or wear, a shirt or hat with a slogan or political logo. The same time, place, and manner rules apply there to this sort of expression. So these are the general rules about what limitations public bodies can put on your and my right to address that body in public comment. We'll end by talking a bit about how bodies can enforce these rules. And it's as an initial matter, it's important that any rule be uniformly enforced. It shouldn't be the case that the body is penalizing one person for the same conduct that it left unaddressed by another. Okay, so the court would look at uniform enforcement of these rules. Of course, the presiding officer can admonish the speaker and request that they conform with the applicable rules. And in more extreme cases, they could even have someone ejected. And I call your attention to a recently passed California law. It was enacted last year that I think generally gets the balance more or less right. It provides, and this is, enacted in the context of increasingly disruptive individuals appearing at meetings, sometimes making threats, sometimes shouting down other speakers. And so this law was passed sort of to help balance all these interests that we talked about before at a time when that has become harder to do. And so under this California law, the presiding officer can have someone ejected for disruptive behavior, but must first warn them that the behavior is disruptive and tell them that if they continue, it will result or may result in their ejection. So it requires sort of notice and an opportunity to knock it off, essentially, before you can eject someone. And it also takes care to define what disrupting means rather than leaving it sort of vague and difficult to enforce. So it says that disrupting means engaging in behavior that actually disrupts, disturbs, impedes, or renders infeasible the orderly conduct of the meeting and includes, but is not limited to, one of the following. One is a failure to comply with the reasonable and lawful regulations adopted by the body, and the other is the use of force or the true threat of force. And in that instance, there's no need for the warning part that I mentioned before. If someone is using force, you can go right to ejection. So as I said, I think this law does a decent job of balancing the interests at stake, although I think the word disturbs is too loose for my liking, and I think could lend itself to varying interpretations by varying people. And also I would like to see the word substantially thrown in there. So substantially disrupts, disturbs, impedes, etc. But overall, I think it does a reasonable job of looking at these interests and trying to find a way to ensure that the meeting can serve its purpose, but that people won't be, shut down and thrown out of meetings on a whim. Now, when it comes to criminal liability for conduct during public comment, the bar is very, very high. In Vermont, our disorderly conduct statute provides that a person is guilty of disorderly conduct if, and apologies for the strange wording of this statute, it's not the best drafted thing I've ever seen, but a person is guilty of disorderly conduct if he or she, with intent to cause public inconvenience or annoyance, or recklessly creates a risk thereof, and then it lists different triggers, and the one that is applicable here is without lawful authority, disturbs any lawful assembly or meeting of persons. The Supreme Court took a look at this statute and said, no, this is clearly unconstitutional on its face. It's overbroad. It would criminalize all sorts of non-criminal speech. And it listed heckling, interrupting, harsh questioning, booing, all manner of speech that has been tolerated pursuant to the rights accorded to the peoples of free societies. And whether that type of conduct could be prohibited by rules and result in ejection is one question. Whether it can result in criminal conviction and fines and jail time is a very different question. And so it looked at that statute and said the only way it can lawfully apply to it is where a defendant's conduct and not the content of the activity's expression substantially impaired the effective conduct of the meeting. So this is where that substantially word, I thought ought to be in the California statute is in place here in Vermont. And then it went on to actually put forth some factors to help determine whether in fact there was substantial impairment, such as cause the meeting to terminate prematurely, or the conduct consists of numerous and sustained efforts to disrupt a meeting after being asked to desist. This is not just a simple interruption. This is not going a minute over the amount of time allotted to you. It has to be very extreme in order to be criminal. And I personally would argue that responding to a public body's invitation to deliver public comments by engaging in speech protected by the First Amendment, addressing matters of public concern, can never criminally disturb a public meeting. These comments, again, with those caveats that I set forth, that the speech is protected by the First Amendment. So I'm not talking about unprotected speech like true threats and that sort of thing, but speech that is protected by the First Amendment, that it addresses matters of public concern, and it's given at the invitation of the public body. I think those comments are consistent with the purpose of the meeting and serve, at least in part, the interests of the speaker, the audience, and the body. So, I would say in such circumstances, criminal liability is simply not the way to balance the competing interests we've talked about throughout this presentation. So that's a general overview of the public's right to address a Vermont public body during comment session, how the body can set restrictions to permissibly balance the competing interests, and how it can react if those restrictions are not followed.
I don't think we have any questions from our audience members, but they did thank you, Lia, and I want to thank you for taking the time to go over this with us. And thanks to everybody who tuned in.
My pleasure. Have a great night, everyone.
All right, take care.